Hello, everyone, and welcome to today's event about India's digital competition law bill. We are going to discuss whether India can regulate its digital boom without stifling its innovation. My name is Lilla Norakish, and I am a senior policy analyst for the Information Technology and Innovation Foundation. I would like to welcome all of you, and thank you for joining us today. As the digital revolution has transformed our world, legislators all over the globe raised the question of whether the traditional legal framework for competition law can handle issues arising in the digital markets, or whether new laws are needed. After the European Union's pioneering Digital Markets Act, more and more jurisdictions are following the path of an ex-ante regulation. Last month, we had an event discussing the early effects of the DMA enforcement and its extraterritorial reach, and today we are going to dive into the Indian perspective. India's digital markets are emerging, and India's legislator is at the crossroads of a revolutionary decision. Today, our esteemed panelists will discuss the Digital Competition Act and provide insights into the potential impacts of the digital landscape of India and beyond. Before we begin, let's briefly meet our speakers. Ashish Agarwal. Ashish is an attorney who has served in senior roles at the Department of Justice and the Federal Trade Commission. At the FTC, he served as an assistant director of the Office of Policy Planning, where he led initiatives to help consumers and examine barriers to the growth of e-commerce. Ashish currently serves as an advisor to the American Edge Project and the US Chamber of Commerce on the competition issues. Nisha Kaur Uberoi. Nisha is a partner at National Head of the Competition Law Practice at Trilegal, leading one of the largest competition law teams in India. She regularly represents clients before the CCI, NCLAT, High Courts, and the Supreme Court of India. Nisha was recognized as the Global Dealmaker of the Year at the Global Competition Review Awards in 2021 in recognition of her advising on complex M&A transactions, and she frequently advises on complex merger control cases. Ram Kumar Pochanandran is part of the AZB Partners Competition Antitrust practice and has over 14 years of experience. He specializes in merger control mandates, cartelization, and abuse of dominant cases. Ram advises Indian and foreign clients on complex matters across various sectors, including digital markets and e-commerce platforms, pharmaceuticals, media, and more. Last but not least, Joseph Fonconiglio. Joseph is the Director of Antitrust and Innovation, leading ITIF's Schumpeter project on competition policy. His work encompasses all aspects of antitrust and innovation policy, with a focus on digital platforms, monopolization policy, and dynamic competition. Prior to ITIF, Joseph worked as an associate at the law firms Sidley Austin and Wilson Sonsini Gottreich and Rosati, where he specialized in civil non-merger investigations and counseling for large technology and financial services companies. Before we delve into our conversation, I would like to encourage our online viewers to actively participate by submitting questions via Slido or for the Q&A session. Now, without further ado, let's start. Nisha, the floor is yours.
Thanks, Leela. Hello, everyone. Does India really need a digital competition bill, which is pretty much self-styled on the European Union's Digital Market Act and seeks to enforce ex-ante legislation in India today, purely premised on the fact that the notion of fairness and contestability should apply to digital markets, and that we should move from protecting the process of competition to protecting competitors. So first, let's test whether startups in India have actually not been vibrant in the Indian digital ecosystem. Well, the answer is far from the truth. India has a fantastic track record in terms of startups, all very much within the ex-post regime. 31,000 startups from 2019 to 2023 have received funding of over $70 billion. India is also ranked third amongst startup economy globally, which shows how vibrant the digital eco-startup system in India actually is. The CCI has been an extremely vigilant competition watchdog and a market regulator, and has in fact initiated over 25 investigations against digital economy players, across sectors which the digital proposed competition bill actually seeks to regulate, which means a large number of these are already ongoing, whether it's e-commerce marketplaces, whether it's search engines, whether it is social messaging platforms, cab aggregators. There is no digital player left who the Competition Commission of India hasn't already initiated an investigation against or pronounced, and it's pending in the courts at the moment. So why is it that at this stage, when the system isn't broken, we need to fix something which is broken? Well, what the proposed digital competition bill tends to do is it wants to regulate digital players, both Indian and international, if certain thresholds are met. These thresholds, both quantitative and qualitative, will apply in the alternative. There's been significant criticism, interestingly, from people who are sought to be regulated and people who are sought to be protected, that these thresholds are either way too low or way too discretionary, which in and of itself shows that at this stage of economic development, the need of the hour is not to have discretionary thresholds and an ex-ante framework where there is no certainty. You cannot have the regulated players have a system of absolutely no certainty, where on the basis of 9 identified core digital services, which the proposed digital competition bill in fact seeks to revisit every 3 years, extensive coverage will happen on a player by player basis. And in fact, even within the designated significantly systematic digital enterprises, otherwise known as gatekeepers under the European Union Digital Markets Act, or SMSs under the proposed UK bill, what will happen is there will be a non-level playing field. The Competition Commission could have a situation where there will not be uniform application to competing SSDEs, and that again leads to further uncertainty. It will dissuade innovation, it will discourage investment. What the proposed digital competition bill seeks to in fact do is in fact slightly more draconian than even the untested experimental European Union Digital Markets Act on which it is based, because under the EU DMA, there is a proposal that individuals will not have personal liability, whereas the proposed digital competition bill in India, in addition to global penalty on the SSDEs, also seeks to introduce individual liability, thereby discouraging entrepreneurship and further discouraging innovation. Apart from that, from the EU perspective, even if you qualify under the thresholds, as a gatekeeper, you have the ability to go and seek an exemption with the European Commission. And there have been several instances, whether it's Microsoft Bing, whether it's Apple's iMessaging, whether it's X's advertisement services, or whether it's TikTok's advertisement services, who have been exempted even though they qualify. In India, that proposal is not there. It's completely missing under the proposed digital competition bill. So you will actually have a scenario of over-regulation, over-inclusion, and again, this will vastly impact innovation. It will damage economic development and discourage investment across the board. For these reasons, the ex-post regime should in fact be further strengthened, as opposed to trying to pick up an untested and experimental Digital Markets Act in the European Union, which has literally just been introduced less than 8 months ago, and premising a new proposed ex-ante law in India, which will have far-reaching implications without actually doing significant stakeholder consultation or without awaiting the results of how ex-ante works in the rest of the world, when India is at a particular stage of economic development, wanting, like the Honorable Prime Minister has said, to move towards being a $7 trillion economy by 2027, will have far-reaching adverse economic implications and will impact digital inclusion, it will impact digital growth, it will actually deter costs across the board, it will disable startups who are sought to be protected from actually being able to scale up, because they will not receive that level of funding and investment, all of which has happened very successfully under the ex-post regime. So this is all of the reasons why at this stage of India's economic development, An ex-ante regime is not really the need of the hour.
Thank you, Nisha. After this deep dive into India's digital markets and hearing about its inspiring startup markets, let's now hear some insights from Ram on the digital competition law.
Thanks, Leela. uh, I mean, it's an exciting time to be in India, not because of the Digital Competition Act, of course. It's exciting both from a user standpoint and also from an app developer standpoint. As a user, you get to use and try out innovative applications and services that are available free of charge. And as an app developer, you're looking at a populace that is quite keen to adopt digital products. In the last 10 years, the pace at which digital products have been adopted in India is quite mind-boggling. Thanks to internet penetration and availability of smartphones at cheaper prices, the adoption has been significant, and it's only gathered momentum over the Black Swan event of COVID. Right, the vibrancy and the dynamism in the startup ecosystem in India is quite palpable if you were to visit one of these startup hubs in Bangalore, Gurgaon, or Hyderabad. Right, how do we protect this dynamic and vibrant ecosystem? Yes, there are no two ways on the fact that we need a fair, transparent, and competitive digital market. Right, there are no second thoughts on that. But answer, of course, is regulation that is robust but measured. Measured being the key word, and that kind of brings us to the reason why we've gathered here. The current draft bill that we kind of discussing today proposes an approach, the ex-ante approach, which is completely untested even in mature jurisdictions. We have little empirical evidence of its success in fixing competition law concerns without stifling innovation and investments into sectors. Right. A More importantly, we need something that works for the Indian ecosystem and the Indian businesses, because India, I mean, there is no one sort of a module that will work for every country. So the model that is being implemented in India will have to kind of work for the Indian ecosystem, keeping in mind the realities of the Indian market. That's one important aspect. Before kind of looking into or doing a deep dive into some of the nuances of the draft competition bill, I would like to place an important data point. There are 5 restrictions that are being placed under the DCP: exclusive dealing, tying and bundling, data usage, leveraging, and self-preferencing. The Competition Commission, in the last 15 years of its existence, has looked into multiple cases in these areas. And in almost 15 instances, the Competition Commission, after analyzing these business practices, have exonerated parties, saying that it's not a problem. There are no anti-competitive effects. And only 4 instances in the last 15 years involving these business practices being followed by digital companies, the Competition Commission has held that there is an anti-competitive conduct. Now, the suggested approach of ex ante, carte blanche sort of an approach that is on the table today for discussion makes everything into a per se illegality approach without any sort of analysis, any sort of testing, right? Which is quite draconian to my mind, and without any sort of market testing, which is extremely important. It is important for the committee to ought to have identified what is the breakdown in the existing system, what mischief is the new law going to fix, right? What are the gaps, and how has the remedies suggested by the Competition Commission till date has not been effective. That is an important test that needs to be done, which is missing in the report. And now kind of going into some of the areas that the DCB touches upon. The first one is core digital service. As Nisha has rightly pointed out, what is the basis for identifying these services? Is this purely basis CCI's enforcement history? Or do we have any data to show that these services and sectors are more susceptible to competition law harm when compared to other services? And that sort of a market testing from an India standpoint is extremely important. And the second concern that I have about core digital service is the catch-all online intermediation service, which has been too broadly worded, which kind of, to my mind, gives rise to a couple of problems. First, it gives too much discretion in the hands of the authority, and then creates significant uncertainty for startups, right? And also an added problem to that is it creates significant uncertainty from an investor standpoint. India has positioned itself as an investment friendly jurisdiction, and the government has taken a flurry of programs and initiatives to ensure that India stays that way. We don't want to take a step in the wrong direction to kind of undo the good work that has been done over the last 10 years. That's one important aspect. And the second aspect that I would like to touch upon is the discretion that has been bestowed or has been given to the authority under the current bill, to kind of determine which enterprise is systemically significant digital enterprise, right? While there has been a quantitative threshold that has been set, which to start with is pretty low, given the Indian realities, there is a subjective element that comes in where the authority bases a set of 16 factors will be able to kind of place a crown on an enterprise saying that from tomorrow you'll be an SSDE, right? Again, this creates a lot of uncertainty, and there's a high risk of false positives in these sort of subjective analysis. And more importantly, coming back to the criteria, the quantitative criteria, the threshold of 10 million users is pretty low because India has a population of 1.4 billion people, right? If you were to kind of even kind of draw parallels to the DMA, which clearly is the inspiration for this legislation, the user threshold is 45 million, which represents 10% of Europe. The number prescribed, which is 10 million, is less than 1% of the Indian population. So this kind of gives you an indication that how grossly kind of low these numbers are. So it's extremely important for us to adopt something which works for India, which kind of protects the innovation and competition in India, rather than just doing a patchwork of a foreign legislation and adopt this in India. To my mind, I think it's extremely important for us to deliberate further on what works for India, and maybe the Australian way is not a bad approach. Undertake a detailed assessment. They've undertaken like almost a half a decade of market study and market assessment to understand what works for them. Maybe that is the way to go forward. Carry out detailed market assessments, service-wise, sector-wise, and understand if there is a breakdown, if the existing exposed regime has not worked. And that's the way forward, rather than just doing a kind of a copy paste of DMA or an inspired version of DMA.
Thank you, Ram, for this practical framing and for providing questions for decision makers on what mischiefs the digital competition law is going to treat in the reality, and how its thresholds affect the company landscape, given that India is indeed a huge market. Highlighting the potential uncertainties and the bill's impact on startup industry seems to be a good topic for further examinations. Now, I would like to ask Ashish to share his thoughts on this issue.
Well, thank you, Leela, and thank you to ITIF for hosting this very important and timely discussion. I'm going to largely echo in many ways what the excellent points that Nisha and Ram have already made. But being here on behalf of the U.S. Chamber of Commerce, which is the world's largest business advocacy organization, we're seeing these sorts of proposals pop up all over the globe, Latin America, the Middle East, other parts of Asia. And my comments, are going to be informed by that experience and perspective and what we've said to other jurisdictions. I really want to make 3 points. One is, before India goes down that road, I do think the policymakers should ask themselves some very hard questions. Are consumers being disturbed right now? Is there a lack of competition in the marketplace? Does the CCI lack the legal tools necessary to address any anti-competitive conduct? And I think the answer to all 3 questions, quite frankly, is no, and I'll talk about that in a minute. The second big point I would make is, if there is a feeling that it does make sense to follow Europe in DMA style proposals, wouldn't it make sense to just wait a little while and see what Europe's experience is with this law? And I will say, with the perspective of some of our members and some consumer groups, that the early returns are fairly negative in many ways from the DMA in terms of how it's affecting Europe's economy. Third point is, what are the longer term potential impacts on innovation and investment in India. And Ram and Nisha both touched upon these. I would add the perspective of, again, from the U.S. Chamber of Commerce. Our members with the U.S. India Business Council think the U.S.-India relationship is a cornerstone of the rest of this century, particularly given that you do have authoritarian regimes out there that are looking to undermine our joint strategic interests. So I do think it's important that we keep that in mind. So those are the 3 points I want to make. Going back to the first one, is there a real need for a proposal like this? Nisha laid out how much competition there is in investment there is in India right now. I think 31,000 startups, the third most dynamic economy by some metrics in the country. Certainly there's plenty of investment. And at bottom, if you read through the lengthy consultation that the Digital Committee put out, at bottom, the reason that advocates are pushing for this proposal is because they think that investigations take too long, and they want to be able to move more quickly. Well, the problem with that is that there's a reason why investigations can take a very long time, which is that most of the conduct that is being investigated is actually pro-competitive. I think Ram went through this. So, exclusive contracts, price discounting, bundling, those all have very pro-competitive justifications before them. They help consumers. Now, it may be possible in particular instances where companies are acting against the interests of consumers. I think Ram mentioned there have been 4 such findings in the last 15 years, and that's fine. But a regulator should have to go and prove that business conduct is actually hurting consumers before they take action to prevent it. As a former regulator myself, I can tell you, yes, you do sometimes just wish you could wave your hand and get businesses to comply, but that's not how the system is set up, and that would be giving too much authority to the government. Second point, doesn't it make sense to see what Europe's experience is before going down that road? The DMA just became effective a few months ago, and already we are seeing reports from consumer groups that their experience has been degraded online in terms of their ability to search for goods and services that they want. Their mapping services, they're no longer integrated in a way that they once were, in Europe. There have been complaints from European businesses, the hotel industry, the travel industry, that their online traffic has decreased due to the DMA. They're having to pay more for advertising in order to get the same levels of traffic. Well, let's see how I would encourage India to take a look and wait a little bit to see how Europe's experience plays out before they go down that road. It reminds me a little bit of the GDPR, which was Europe's great privacy initiative. Certainly did and has set the standard, but with a little bit of time and experience, I think we've really seen the detrimental effects that the GDPR has had on Europe's economy. And I'm afraid that, and I expect, quite frankly, the DMA is going to have the same effects on the goods and services that are available to European consumers on the levels of innovation in Europe. Which brings me back to the third point, and arguably in some ways, the most important point: what would be the effects of this proposal on innovation in Europe? I can't do as good a job as Nisha and Ram have of talking about India's economy. So let me share the experience. Let me draw a contrast between the United States and Europe. The United States, for decades, like India, has had a very light touch regulatory regime. We don't shoot the winner. We encourage investment and innovation, and we allow companies that have innovated to reap the rewards of their investment. Well, by any metric you could point to, the United States is blowing Europe out of the water in terms of our growth, our venture capital investment, the goods and services available to consumers, the world's largest companies. It's all here. And India is going down that road now, and we would urge you to continue down that path. Europe leads the world in regulation, it does, but in little else. Would you rather have a leading economy or a leading regulatory environment? I think India has a very important choice to make as it considers the DCB. Thanks.
Thank you, Ashish. Raising awareness of these seismic changes in the competition landscape in India is a very significant point for further discussions. We are fortunate to have practicing experts from India and the USA with us today who can tell more about the potential unintended consequences and the practical implications of such law. Indeed, evaluating how the EU's DMA plays out in the practice is vital before India or other jurisdictions decide to follow the path of an ex-ante competition regime. Now, without further ado, let's hear from Joseph.
Thank you, Leila, and thanks to the other panelists for joining us here at ITIF, as well as to everybody tuning in. I want to pick up, I think, where Ashish left off regarding some of the historical context here and what lessons we can learn from history, both in the United States as well as in Europe, and start with a quote from Confucius, that when it comes to defining the future, one must learn from the past. And what I want to suggest is that when we're thinking about crafting a competition policy for the 21st century, amidst the ongoing waves of creative destruction with digital and AI, the history of competition policy in the 20th century with its own technological revolutions and changes provides a natural experiment for Indian policymakers to consider, to look both at what works and what doesn't. So to do this, I want to raise two key issues that Indian policymakers need to grapple with when designing a competition regime, and which both frankly involve a balancing between error costs, or allowing anti-competitive behavior or disallowing pro-competitive behavior, and also minimizing administrative costs, which reflect the costs associated with determining what conduct is lawful and administering the regime. So the first distinction is between antitrust as a form of law enforcement, and where courts challenge anti-competitive conduct after the fact, and then, as discussed, antitrust is a regulation framework where there's some sort of government approval that is needed ex ante. And there are trade-offs theoretically with both approaches. So law enforcement can minimize error costs by actually targeting the specific behavior that is harming consumers and competition, but it can be more administratively costly with long drawn-out investigations and litigation. And likewise, conversely, regulation can address harms more quickly by doing things ex ante, but also can result in greater error costs by chilling conduct that may actually end up being pro-competitive in its effects, as well as doing other things like creating barriers to entry for small firms. So what lessons can we learn from history about which model works best? So by the mid-20th century, America's political economy was highly regulated in many industries. Antitrust itself was not exempt from the regulatory frenzy, the FTC using its rulemaking authority so much that it was termed the national nanny by the Washington Post. And the results overall were unclear legal standards, diminished innovation, and even in some cases, regulatory capture. Unsurprisingly, beginning in the late 1970s, America began a process of deregulating various industries like railroads, trucking, telecom, and airlines, as well as scaling back FTC rulemakings. And while the results obviously vary by industry, in general, deregulation helped grow the economy and support innovation and improve product quality. And, a good example is the media industry, which saw tremendous growth and innovation following the decades where cable was deregulated, and which ultimately disrupted the broadcast incumbents that were protected, frankly, by cable regulation. So a second and independent issue from ex ante ex post enforcement versus regulation involves whether the competition regime is going to look at conduct's actual anti-competitive effects or market performance, or whether it's going to rely on per se rules and structural presumptions. So in the case of the latter, as Ram and others have already intimated, the benefits of per se rules and structural presumptions are an easy to administer regime where courts don't have to engage in complex weighing of harms and benefits. But there can also be error costs because per se rules can chill conduct that may be pro-competitive, resulting in false positives, and actually limit the sort of innovative behavior that actually can correct market failures the best way in the long run. And by contrast, you have an approach that looks at effects. Well, that can limit error costs because you actually see what the conduct does rather than condemning it ex ante. But it can also be more administratively costly to do so, again, with analyzing the effects and litigation, et cetera. And it can also actually create uncertainty as to figure out which in advance, which behavior is going to be unlawful. So again, I think history is helpful in sort of figuring out which of these two paradigms works best. In the 1970s, America and Europe started to take two very different approaches on this issue of evaluating anti-competitive conduct, especially with respect to the unilateral behavior that's really kind of at issue here. So the consumer welfare standard adopted in America generally condemned business conduct only when it resulted in consumer harm, rather than just an increase in market concentration, and also accounted for pro-competitive justifications. Europe, by contrast, went with a model that did not generally analyze economic effects, and which sought to protect small competitors. And now, as Ashish has mentioned, whereas Europe has no large digital firms, America led the digital revolution. Of the 10 most valuable companies in the world by market cap, 8 of these are in high-tech industries and 7 of these are American. And there's a reason why the European approach was problematic from this standpoint. The American model is consistent with the Schumpeterian scale-driven innovation competition, which can be chilled by things like per se rules and structure-focused conduct regime. So the upshot, I think, is that when it comes to promoting innovation in a world like we have now of rapid technical change, recent history suggests the best thing for policymakers to do is adopt a presumption against regulation and in favor of relying on law enforcement unless there's really clear evidence of persistent market failures. Second, per se rules or structural presumptions that don't fully analyze conduct's effects on market performance or in a way that considers pro-competitive justifications are likely to chill the innovative behavior that best corrects market failures and creates a strong digital sector, which is also a key driver of economic growth that is, especially crucial to emerging economies. Unfortunately, India's competition bill seems to be lacking in both of these respects. First, by imposing a regulatory regime that I think has already been discussed by Nish and others, doesn't seem to be tethered to any real market failure. And second, by adopting this approach of per se rules for several forms of business conduct that is, again, has already been said, are often pro-competitive, pro-consumer, and pro-innovation. So I'll stop there for now.
Thank you, Joseph. Learning about the USA's and the EU's regulatory history and their relations to innovation could be beneficial indeed for India and other jurisdictions before they change their existing regimes. Now, let's stop for a moment. We talked about the proposed law and also about its impact on the digital markets. But what do the Indian digital markets look like? Does India or its digital markets need this regulation? Ram, what do you think about this?
Thanks, Leela. So as I mentioned in my introductory remarks, and Nisha also kind of pointed to some statistics, India has quite a vibrant digital ecosystem. And government initiatives such as Digital India and Make in India has contributed to this process and strengthening the digital ecosystem in India. The proposed legislation, which is ex-ante and which is carte blanche in its approach, is going to create serious hurdles for a lot of Indian companies, right? Some of these Indian companies, going by the threshold that the law proposes, they might qualify as SSDE, but when you kind of compare them to the international peers, they're still very small. And this is despite the fact that these companies are making the India of today, right? They are the ones who are actively contributing for in nation building. For example, let's take quick delivery service, right? This particular sector has kind of gained importance in the last 4-5 years, and they are creating significant employment opportunities to gig workers in the country, right? But if you were to kind of apply the SSDE threshold, and let's take an example of Zomato, right, which is one of the popular players in the Indian market, right? They would qualify as an SSDE. But if you compare them with some of their international peers, right? If you compare them with DoorDash, they would only equal 8% of DoorDash's GMV. And if you were to compare them to some of their Chinese peers, right, like Meituan, they'll only be 3% of their Chinese counterparts' revenue. So there are Indian companies who are coming up with innovative products, but have they reached global scale? Is it the duty of the government to kind of formulate regulations and programs to aid them to scale that height? It's definitely important, right? So it's extremely important to kind of formulate regulation that fosters innovation. But of course, it's extremely important to understand not to kind of create any restriction or differentiation basis nationality of a company. So it's extreme. The key point is, we don't want to kind of set thresholds that are significantly large, which only catches companies from a certain nationality. At the same time, we don't want to kind of formulate thresholds that are too low that will catch everyone, right? So the most important thing is, it is important for us to assess what best serves the interest of India and to kind of do a detailed assessment, sector-wise, service-wise, before we formulate these thresholds and implement these regulations. I'll pause here for a second.
Leela, to add to what Ram was saying, and taking off from where Ashish very strongly brought out a beautiful point, that one part of the reason by the committee for the proposed digital competition bill is the ostensible delay, both in the investigation and then ultimately in courts, right? Now that still continues. India, in fact, has had massive changes to its competition law for the first time in 15 years. There was a committee which was formed in 2018 by the government to look at bringing international business practices and best practices to ensure that our competition act is in line with global best practices. The committee decided that India does not need a separate digital law in 2018. Parliament passed the Competition Amendment Act last year. We now have from this year, because the regulations are live, settlement and commitments, which will significantly cut back time, right? So perhaps it's time to actually test out these new changes under the Indian competition regime to see if at all then there are still delays. And if there are delays, the other thing that really needs to be done is we need dedicated competition benches across courts to hear competition matters, for competition jurisprudence to evolve. So it is not purely a delay at the investigation stage. There is more than enough ability for the CCI. The CCI needs far more resources because they're doing a fantastic job, right? But they're significantly under-resourced and understaffed. They've started a data market and digital unit, which at the moment doesn't have quants, doesn't have data scientists, right? It has economists, it has lawyers. So the CCI needs a lot more tool strengthening in its kit today for the law to be strengthened under the existing ex-post regime. It doesn't really need a new ex-ante regime at this stage of economic development.
Nisha, that's just such a great point, because if the concern is that investigations take too long and my goodness, digital markets move so quickly, the sorts of reforms that you're talking about really would address that very narrow problem rather than making the seismic change of moving to an ex-ante regime. So I do hope that policymakers consider that. I also want to just follow up on a point that Ram made about the startup culture in India. I really do have concerns that the DCB could jeopardize that culture. They've done surveys in Europe of European entrepreneurs, and just to try to ferret out why is it that Europe, really from the 1970s to today, has fallen behind the United States. And some of the things that come up include regulatory uncertainty and a relative inability to get financing for their ideas as compared to the United States. Now, lots of reasons for that, labor policy, other issues. But I do think that competition policy is part of that. And if you move to this ex-ante regime that really makes it more difficult for larger companies to invest and subjects them uniquely to regulatory requirements, I do think that could have significant and damaging downstream consequences on smaller companies that are trying to grow and expand into international markets.
2 quick points for me here, I think echoing what folks have already said. First, on the startup issue, I agree. And one data point that I've seen is not just the vibrant startup community in India, but the fact that the unicorns are also very strong, especially the last couple of years, which suggests an ability to scale for startups, which I think is very important here. And with respect to the argument about ex post and creating longer administrative costs, I think there's an issue with the report here about not proving enough. So even if it's true that ex post investigations can be more administratively costly, and even if it's also true that ex-ante regulation can be complementary to ex post, that doesn't get at the fundamental question, I think, about whether or not an ex-ante regime is actually going to improve the status quo, and whether the error costs that result from an ex-ante regulation approach are not going to outweigh the gains that may be had from reducing administrative costs. So that's really the key issue. And again, I think it's an oversight, at least in the report as I read it, that's never really taken directly head on.
Thank you. Before we move forward, I would like to remind our audience to submit questions they want to hear insights from our esteemed panel. And next, Does this bill create any uncertainties regarding its scope of application? How much variation do you expect regarding the individualized codes of conduct? How does this bill fit into the competition or Indian regulatory landscape on competition? Nisha, would you like to start to answer?
Thanks, Leela. How much uncertainty does it create? A lot. How many red flags? Tremendous, right? Why is that so? I think Ram addressed it early on when he said there's a lot of wide-ranging discretion. When there's a lot of wide-ranging discretion and there isn't certainty, then you do not have common rules which will apply uniformly to competing SSDEs. So then you actually have a situation of competing players who might both, for instance, be in the food delivery service, but are bound by differing obligations, and it'll impact their inter-se competition significantly. It will also create a world of haves and have-nots, where there will be a universe of players who will be regulated and will not be able to expand further. It will impact their innovation, versus some people who will not have the ability to scale up because investment then will get impacted. So on both ends of the spectrum, there's going to be significant damage, and it will be detrimental overall to the economy. In addition to this, unfortunately, the proposed digital competition bill has this whole concept of a one-size-fits-all approach, which doesn't really work when you've got differing digital players offering completely different services, operating in different markets with different competitive constraints. India at this stage also needs champions of scale, size, who can then stand up globally and compete with the best in the world. We've had some brilliant unicorns, and they really need to now continue to grow. This is not the time and the trajectory to stop that growth. Where the DCB has a fundamental flaw to me as a lawyer is there is absolutely no objective justification defense. And like Joe very rightly pointed out, pro-competitive effects are not taken into account at all. It is simply a per se application and a prohibition across the board of certain forms of conduct, right? So for instance, there is absolutely no credence given to security and privacy, which are key in a data-driven world. You cannot, in today's global world, have a situation where security and privacy are not paramount. And that really needs to be recognized and is a fundamental flaw. The other massive fundamental flaw is the bill assumes this whole concept of digital players when India as an economy is digitizing, which means even traditional businesses are going digital, right? So this really is something which will overall significantly impact all players, not just purely digital players. And worse, you've got a situation where for non-compliance, or for perceived non-compliance, you've got global penalty, which is applied at the group level and therefore doesn't just cover core digital services. It goes well beyond the so-called errant service line and impacts an entity in terms of all of its turnover from all of its service lines, even those which are not regulated. Right? So that, in a nutshell, are some of the major flaws of the proposed digital competition bill.
If I could chime in on 2 points there, just adding to what Nisha just mentioned. And to my mind, there are two points that creates uncertainty here. The first one being, as I mentioned in my introductory remarks, the identification of a core digital service itself is quite uncertain, and also the designation, which again creates uncertainty. And I would like to kind of take a cue from what Ashish helpfully mentioned when he was making his introductory remarks. There's a lot of difference between what has happened in the US and Europe. Right. In India, these startups are still perfecting their business model. Right. Some of these might be large according to the definition set under DCB, but they're still perfecting their business models. They're testing what works well for them and how can they kind of using that business model scale up. If you are imposing such extensive and kind of prescriptive rules, that kind of takes away the independence or the flexibility that a digital player would want to scale up, right? And this will have an impact on the products that they make and also the kind of investments that they'll be able to attract. That's one extremely kind of crucial point that lawmakers will have to bear in mind. That's something that I want to highlight. And the second aspect is, how will this law interact with the existing set of legislations that are there, right? The law talks about data usage, and we have a separate Data Protection Act. How will this kind of interact with that law? What will be the obligation? What happens to the existing Competition Act? Is there a holiday from the rules that are applicable from a Competition Act perspective? So if somebody is caught under the DCB, so will any consequence from a Competition Act not visit them? So how are these laws going to interact with each other? And there are, and as Nisha has rightly pointed out, some of the traditional businesses are transforming themselves into digital businesses, right? And some of these traditional businesses have their own sector regulators that they are answerable to. And then there are provisions under those sector regulations specifically regulating competition. How will this work? And some of these sector regulators have already ex-ante prescriptive pricing powers. For example, the telecom regulator, right? How will this coexist? So we need to actually find answers for a lot of these questions before rolling out an ex-ante legislation, according to me.
I'll just make one quick point, building on what Nisha and Ram just said, which is that the amount of discretion that the bill creates, coupled with the uncertainty with the intersection of sector regulations, as well as the lack of real objective standards, it's just an invitation to politicize competition law. I mean, I'll tell you, when I was a federal regulator, there would, some congressman would come in wanting to help his hometown company. There's always some company, coming in asking for some sort of relief because they think that their competitors are competing unfairly. And believe me, every company out there thinks their competitors are somehow acting unfairly. And we're able to push back on those sorts of complaints and requests because we had objectivity in our antitrust laws in the United States. And I do fear that the DCB is moving away from that.
Yeah, just 2 quick points for me. I want to focus in on the SSDE issue here with respect to uncertainty, because I think that's really kind of a key point, obviously, with respect to who the bill is going to apply to. And, from an economic standpoint, regulation, when done right, is about responding to market failure. And, a necessary but not sufficient condition of market failure is having some sort of market power. And I think, as I read the bill, for either the quantitative thresholds or the qualitative thresholds, there is no market power criterion there. There's a market power factor for the qualitative factors, but it's not a requirement. So again, the idea here is that the bill is going to be applying its prohibitions to companies that don't have any market power, and I think that's going to result in a very overbroad application, and again, sort of gets away from the economics that underlie sound regulation. And again, the lack of clarity with respect to the qualitative tests and the 16 or so factors that are listed there, that's not only going to create, as Ashish mentioned, sort of a ripe opportunity for picking winners and losers and potentially regulatory capture, but it's also going to create tremendous uncertainty for businesses trying to plan their future and not knowing as they grow whether or not this regulation may apply or not, assuming they don't hit the quantitative threshold. So maybe I'll just stop there with that.
Thank you. I would like to continue with the bigger picture, with the question that reflects on the bigger picture, because we were talking about the domestic policy aspect and also about the lessons from Europe and the USA, but can we discuss how does the bill affect India's geopolitical situation, especially with regard to its relationship with the USA and in the light of the rise of China as a techno-economic leader? Ashish, do you want to start to respond to this question?
Sure. I think, in fact, I know that India is viewed as just a huge strategic partner, across the political spectrum here in the United States, across the economy of our largest members, and there certainly, is a belief that the United States, India, and some of the other Western democracies in Europe and Asia really do need to align our strategic interests to counter the rising competition from China and other authoritarian nations. There is a concern that has been expressed by our Secretary of Commerce and many members of Congress that Europe's DMA is very much selectively targeted at U.S. companies. That causes quite a bit of consternation here. I don't think that's so much the case, with India. I think that just sort of, following Europe's lead, but there is a concern about selective application, of the law without adequate justification. If the U.S. and India are able, and other Western democracies are able to work together, I think we can, collectively do quite a bit to check those ambitions. We've had reports from our intelligence agencies, this is all public, that China is stealing something in the nature of $500 billion of intellectual property just from the United States alone. And if India and other countries are adopting policies that make it even more difficult for our U.S.-based companies to protect data privacy, to protect cybersecurity, I think that could have damaging long-term consequences on our strategic relationship.
Yeah, let me jump in here as well. And first, I want to be clear, because there's some mention in the report that amidst this U.S.-China rivalry, which is going to define, frankly, the 21st century in many ways, digital regulation is not at all likely in the United States. There's a couple bills that have been tossed around here, but they're all over 2 years old and highly unlikely to be enacted this Congress, let alone, frankly, in any potential future Republican administration. And there's a simple reason why, from a realist perspective. The U.S. is not going to deviate from the model that I and others have discussed, has worked very well at driving innovation at a time when its technological leadership and those of its allies is more important than ever. So that's, I think, point number one. Point number two, there is no doubt that the bill is likely or may impose heavy costs on American firms, and this could create some tensions within the U.S.-India relationship. So I really think India here has a sort of a clear choice. It can follow sort of the U.S. path, a historical path, which will allow India to build up its own tech firms and innovate together with the United States. Or if it goes down the path of regulation, it's going to stifle not just American innovation, but also Indian regulation, as well as potentially create frictions between the U.S. and India. And really, when you get down to it, there's only one country that benefits from those two things, and that's China.
Nisha, Ram, would you like to jump in?
Absolutely. Like I already mentioned, security and privacy is key. In India, we've already had a situation where TikTok has been banned, right? It's being regulated under ex-ante in Europe under the DMA. That itself shows the differential. The US has been one of our strongest trading partners and our tech collaboration partner. And in fact, I'm going to say that today we've got Indian companies who are champions who actually even compete with the US companies in the tech space. To give you an example, in the cab aggregator space, Ola, which is Indian homegrown, is in fact larger than Uber, right? And we've got both in our market, both competing successfully, neither of whom should be curbed and stopped, because that is what we need: innovation and consumer choice. The proof is there in the pudding.
I completely agree with my fellow panelist that it's extremely important for us to kind of weigh in the long-term strategic interest from a geopolitical standpoint before embarking on this rather ambitious / dangerous exercise of putting in place an ex-ante regulation.
And Nisha, let's remember that two of the largest companies in the world, Google and Microsoft, are led by Indian Americans. I think that's something we can all be very proud of.
Thank you for the contributions. Just a quick question. Is there a silver lining?
At least we're not able to see that one, the silver lining in the entire exercise. I think the long-term impact of this, I mean, if implemented, is going to be quite damaging. And the place where we are sitting today, at least as a lawyer, I'm not able to see any silver lining of this. Over to you, Nisha.
I think the silver lining is it's still a bill. It could go back to drawing board stage. It could go into cold storage. It could be vastly improved on. And if needed at all, it can be reintroduced at the right stage of economic development when India is a genuine digital superpower. Now is not the time. It is not law yet. And I think that is the only silver lining to this.
If there is a silver lining, if it gets people talking about what is sensible competition policy and what is good regulatory framework for encouraging innovation, I think that's a good thing. But as Nisha and Ram says, that it'll be easier to see that silver lining if the bill doesn't proceed as it is right now.
So I would say the silver lining here is that we do have some history that we can learn from if we want to. And, I point to the United States, but also Europe. And, also with respect to some of the language here, I mean, the core parts of the ban, I mean, fair and transparent dealing, non-discrimination. We've got a lot of experience with those types of concepts in the United States. And, we've learned the hard way how that can work out with things like the Robinson-Patman Act, for example. And, really with just many of these bans, they're all getting at sort of conduct that we know is often pro-competitive. So, and frankly, can be utilized by small firms, ultimately, things like tying and bundling to compete with larger rivals, right? So I think history is here if we want to learn from it. But unfortunately, human nature suggests we don't always do that.
You made some very vital points on the proposed laws, reality, and also on its tangible effects on Indian law and digital markets. As a takeaway, we can see that while the DMA represents a pioneering effort to address issues in the digital markets, it's essential to recognize that Europe's regulatory and economic environment is really distinct from India's. As Ashish pointed out, a wait-and-see approach can be wiser than following trends that might not fit well in India. As Ram highlighted, India needs Indian solutions for its digital markets. Nisha raised attention that there are existing solutions in the Indian legal system, and those are or could be able to tackle competition issues occurring in the digital markets. Finally, Joseph highlighted the importance of learning from the past and understanding the history of the USA's and the EU's antitrust regulatory approaches and their relations to innovation. Thank you to our panelists for their valuable insights, and thank you for our audience for their engagement. Finally, I encourage the audience to stay tuned for the ITIF's upcoming events.
Thank you, Leela. Thank you, ITIF.
Thank you, Leela. Thanks, everyone.